This is Steve Carlson again, finishing with part two of my response to the submissions of Senator Al Franken and Secretary of Mark Ritchie for the election contest trial, which begins tomorrow on the 18th in St. Paul, before a panel of three judges appointed by Chief Justice Lori Gildea, the state of Minnesota. Beginning part two with standing and justiciability. This case is justiciable just as the Powell case was, since it is justiciable citing Bell v. Hood. The case is one arising under the Constitution within the meaning of Article 3, since petitioner's claims will be sustained if the Constitution is given one construction and will be defeated if it is given another. That's Bell v. Hood 325 U.S. 678. And also, this litigation is justiciable because the claim presented and the relief sought can be judicially resolved. Again, from the U.S. Supreme Court in Powell versus what was his name? McCormick, who was the Speaker of the House, who wanted to exclude Powell even though he was elected. Very similar case, leading case regarding Article 1, Section 5. Although this Ramsey County panel is passing these claims through to the Senate, and so the justiciability required is narrow, this election contest is justiciable because if the Constitution is read to say that the U.S. Senate is the exclusive judge of any points beyond, and actually even any points about the count, then this panel has to take evidence on those points in the canvassing board certification and pass it on. That's all. Hopefully, this panel will see the importance of ensuring that all evidence is allowed to be submitted and taken before passing it on. But if all evidence is not allowed, the U.S. Senate could allow that evidence to be submitted on findings of fact. There's no findings of fact, just evidence from which it can be inferred. That's a little slip there. Or conclusions of law. So there's no findings of fact or conclusions of law. And even though the contestees constantly urge this panel to take, can by Minnesota law be taken. So they're asking them to break the law and reach findings of fact and basically determine the case when they cannot be the judge. But that does not, contrary to their argument, deprive this panel. Just because they can't do those things doesn't mean it deprives this panel of any jurisdiction, because the jurisdiction is given and defined by the Minnesota election laws, fixed before the election. And the role is just as I have just described. So all that argument is just noise, and is delaying and preventing this panel from properly exercising its jurisdiction. While the Secretary insists I am attacking Minnesota courts, it is really he and Senator Franken who are attacking the jurisdiction of this court properly prescribed by the legislature to aid the U.S. Senate. The Minnesota legislature has this power to prescribe this judicial role under the U.S. Constitution, Article 1, Section 4, the same one that enshrines the vote, according to Yarborough. And so does the U.S. Senate, as a legislative body, have this same kind of power. But for federal elections, of course, the federal Constitution prevails. The origin of this legislative power is described. This power is entrusted to the Senate to sustain the free choice of its constituents. Justice Story, Commentaries on the Constitution of the United States, cited in the Heritage Guide to Constitution, fully revised, 2nd edition. And the Senate's power is nonpartisan. The power is entrusted to them to be guardians of our Constitution and our democracy, not to protect the Democrat or Republican Party against third parties, or protect incumbency through internal political power. Their actions may also be reviewed by the U.S. Supreme Court. But as for the seating, once it is done by the Senate, it is moot, as McCollum's seating question was moot. But constitutional questions, especially important questions, which would repeat, if not remedied, and affect future elections, could be reviewed judicially. The Minnesota Federal Court did that, and I am asking the U.S. Supreme Court to grant certiorari on that and on this. So these important questions affecting future elections, including the one just concluded, 2014, but also the one I intend to run in 2016, either President of the United States or U.S. House member, will be secured against this kind of proceeding by any other well-funded incumbent or established candidate for federal office who works around the requirements of Minnesota election laws. This includes the U.S. and Minnesota constitutions and federal election law, which protect voting rights. I have standing because I have been injured by the great irregularities and deliberate, serious, and material violations of Minnesota election law, including Article 1, First Amendment, 15th and 19th Amendments of the U.S. Constitution, and Article 7 of the Minnesota Constitution. As the elected nominee of the Minnesota Independence Party, which is a Minnesota major party, but which will be decertified as a Minnesota major party as a result of the challenged results, not the vote tally, but the distortion in the count caused by the irregularities and violations charged in the instant contest. The election law cases cited are not congressional cases, but school board or state or county commissioner races, which are not in the United States Constitution, like this one is. The references they made to Senator Franken's 2008 campaign and contest are about a challenge to the vote count, which this one is not, and so the side issues there, in that case called, I believe, Sheehan versus Franken, to the extent that they may have been correctly decided under state law, cannot be applied here. This panel may not be the judge of the elections, returns, qualifications of the members of the U.S. Senate. But the Senate, in addition to Section 5 of Article 1, also has interest in protecting the vote in Section 4 of same. Now, concerning contestees' assertions that the contest has no legally valid grounds. First, I am asking this panel to adopt my amended contest for the reasons set forth in my motion filed and served therewith on December 16, 2014. Further, as stated supra, this panel simply cannot stand as judges of the merits of this case because all power to judge lies with the U.S. Senate, as discussed above in Part 1. This panel has been convened under the authority of the Chief Justice of the Minnesota Supreme Court pursuant to Minnesota Statutes 209-12 for the specific purpose to take evidence required for consideration and judgment by the U.S. Senate, sitting as a judicial body to judge this contest. That being said, contestant is mindful of the concerns and interests as well as the power of the Senate as it will sit in judgment, and certainly these same points by contestees will be raised and must be answered in that proceeding. The issues raised by contestees about the legal validity is counterposed against my assertions regarding the U.S. Senate election's invalidity include 1. The assertion that the contest, and I have amended it, contains no allegations that would actually call the canvassed vote counts into question. 2. The assertion the contest contains no allegations of actual, deliberate, serious, or material violations of provisions of Minnesota election law. 3. The assertion that I was, quote, unconstitutionally denied state court relief, unquote, during the election is not a valid ground to question the election results. 4. The assertion that I was, quote, illegally prevented from participation in DFL election caucuses, unquote, during the election, again, is not a valid ground to question the election results. 5. The assertion that I was improperly excluded from broadcast debates during the election is not a valid ground to question the election results. 6. The assertion that I was unlawfully denied access to voter email addresses during the election is not a valid ground to question the election results. 7. None of these are either irregularities or serious material and deliberate violations of Minnesota election law. 8. This panel has authority to dismiss the contest. 9. The contest does not allege violations which would affect the outcome. 10. The panel does not have jurisdiction to rule on the contest claims. 11. Contest does not allege material involvement by Senator Franken in every alleged irregularity or violation. 12. Claims are precluded by res judicata or collateral estoppel. 13. Contest does not allege violation of any laws. 14. Contest shows no First Amendment claim. 15. Contestant has no constitutional right to participate in DFL caucuses and conventions. 16. Any attacks on binding Supreme Court decisions, or the Secretary says any Minnesota courts fail. I will address these issues for the sake of Minnesota election laws being followed and for the sake of addressing the supposed validity of an election containing all of these flaws. not just some, but in a systematic assault to annihilate the campaign of a major political party nominee for U.S. Senate by violating the First Amendment, 14th, 15th, and 19th Amendments in Article 1, Section 4, U.S. Constitution, and Minnesota laws and Constitution, and the equal time provisions. So, regarding the contestee's argument that the election contest fails to state a claim on which relief may be granted, contests are a different kind of judicial activity in which the Minnesota legislature has assigned to the Minnesota County District Courts and the Minnesota Supreme Court the role of sharing with two legislative bodies, the Minnesota legislature for the state legislative races and the Congress, that is to say both the U.S. House of Representatives and the U.S. Senate, judicial roles to be they are to be the judge of the elections, returns, and qualifications of its own members. So this applies to both the state legislature and the Congress. The courts have interpreted this as the sole judge, but as set forth supra, this role is exclusively the province of the U.S. Senate, not the Minnesota legislature. What is within the province of the Minnesota legislature is to prescribe laws which ensure that this exclusive U.S. Senate judicial role of determining the validity of claims brought to it in elections contests. So first, there must be an election contest provided for in Chapter 209. Next, there must be collection of evidence and certification thereof where a U.S. Senate campaign is concerned in 209.12 Congressional Office. This could be a very valuable thing if the chief elections officer, court clerks, and Minnesota courts were to follow it. It would add value to the information received by the Senate and might enrich and expedite their own resolution of the election contest. But in reality, even to do this is to usurp a duty of the U.S. Senate. Well and good, except where a judge, a clerk, decide to charge for this beneficent service to the U.S. Senate, charge money. Where Minnesota courts, were they not to do this, it would come directly to the U.S. Senate, who might well choose to do the very same thing this court is doing now. And so to usurp that role by charging for it and blocking it, this undercuts the U.S. Constitution. And as I am saying, prevents the vitality of periodic elections to feed the membership of the critical U.S. Senate as a part of a Congress constructed by, of, and for the people. It is difficult to imagine that if this procedure is blocked by anyone in the state acting under color of law, that resolution of this blocking would not be concerning a duty by any individual or a court clerk preventing Congress, as intended by the Minnesota legislature, as well as the Supreme Court, from being the exclusive judge of the election contest. In quoting that the Minnesota law is that the Minnesota Supreme Court will review before the election, quote, any wrongful act, omission, or error of any election judge, municipal clerk, county auditor, canvassing board, or any of its members, the Secretary of State, or any other individual charged with any duty concerning an election. And yet this is exactly what happened when the Minnesota Supreme Court did with the 2012 election contest, in which a Ramsey County District Judge, Elena Osby, inserted herself as a judge in this matter, deciding without any statutory authority, calling for fees to be paid, for the court to collect the evidence and forward it to that, in order that the U.S. Senate may evaluate it in the contest and address it through a U.S. Senate resolution. Clear violations of the Constitution, charging a fee to block the evidence from getting to the U.S. House when a contest was raised, and forwarding the election certificate despite the existence of that contest. Because the House did act based on receiving the election certificate from a chief elections officer who knew the courts have received an election contest, and therefore under Minnesota law it was unlawful to forward that certificate, the issue was moot and not reviewable by the courts, because Betty McComb was already seated rightly or wrongly. However, the constitutionality of the House action, as in the Powell versus McCormick case, is judicially reviewable. That case was limited to the issue of what is a qualification under Article 1 of the Constitution. Therefore, in that case, where the House tried to pass off an exclusion action after seating Powell as a judgment based on qualifications, the Supreme Court ruled the action unconstitutional. That action is very different than the claims raised in this contest. As a byproduct of the presence of the Independent Party as a major political party under Chapter 200, legally equal with Senator Franken's party, there is a new twist in the U.S. Senate races. The IP has a statutory right to name a nominee on the general election ballot through a primary election. This is a Minnesota election law. And since it is a political party, it must be treated with the same dignity and respect with which the Supreme Court treated the association rights of just independent voters who had associated to get an independent presidential candidate on the ballot in a case decided in 1983. I've already made the case above that the total annihilation strategy, Senator Franken acting like what major party nominee? I don't see a major party nominee. He's nothing, nihil, has passed this threshold of an invalid election. I also want to look at contestees' contentions about the four grounds I presented as irregularities and serious material and deliberate violations. There is a distinction between these two grounds, each of which are present in the state law on contests. To the argument that it is not proven or directly alleged at this point that Senator Franken actually carried out these, I say, first, as a party officer of voters and professionals he voluntarily associated with, he is as responsible for those party rules in the Constitution as any other member. For to be a member, he needs to agree with the principles in the DFL Constitution, and so legally he is considered to be responsible for having read them. The same goes for Mark Ritchie. This is in addition to his statutory role to file the DFL Constitution. Now he is presumed to have read and understood it. Does this constitute state action? I believe yes, but for the contest this isn't as important. What is important is that these deviations from the laws and Constitution are irregularities, even taken individually, serious irregularities. The courts won't enforce the laws. The Chief Elections Officer and Attorney General don't want the laws enforced in something as fundamental as a congressional election. In segregating the DFL caucus through voting delegate suspect quotas, public information for expressing political views in an election is denied to the candidates, while the incumbent DFL, including Senator Franken, is allowed to use official information resources. The incumbent bans the major party nominee from all the debates in a deal worked out with another major party nominee. And all of these tend toward one thing, removing the IP nominee and his views from the voters' information and perception. All the while, the media is creating a deceptive, destructive image of the candidate who is not allowed to communicate. Hardly a democratic state, hardly democratic features. And this is a burden, separately and combined, on the First Amendment, political expression, and political association rights secured by that Constitution that enshrines the vote as a bulwark against tyranny. This is a political party, the Minnesota Independence Party. It benefits from all the rights conferred by the U.S. Constitution and Minnesota election laws. And an issue in this Senate contest is whether the U.S. Senate, stepping out of its role as legislators, seeking to create public policy through elected representatives, and into its white knight guardian of liberty and existence of the republic, will pay the same attention to associations of independent voters and not the big national parties that the Supreme Court did. In the 2012 federal case, Carlson versus Ritchie, the Minnesota Attorney General began to ferociously defend the practices of the DFL, citing cases from the U.S. Supreme Court, which upon examination derived from a case intended to benefit independent voters, specifically the case Anderson versus Celebrezze, 1983, at the U.S. Supreme Court, said that associations of voters, independent voters, could not be burdened in their First Amendment rights of freedom of association. The specific issue in Ohio is whether John B. Anderson and his associated voters in Ohio needed to get on the ballot through petition at exactly the same time Republicans and Democrats chose their nominees by primaries. So the petition had to coincide with the national party primaries. And the Supreme Court said that even if the nominees were all chosen at the same time, imposing the same requirement of organization on the independent unassociated voters to associate on the same time frame was an unreasonable burden. The Ohio Secretary of State, Calabrese, had to justify it. He couldn't. He said things like, "We want all the voters to know all about Anderson at the same time they learn about these national nominees." Ohio said, and actually the Supreme Court said, that does not justify the burden. It violates the First Amendment. Likewise, where Secretary Ritchie could take official resources home from the office, email addresses of voters and donors, and raise funds with them, but an Independence Party House nominee who just wanted to make a quick one or two mass emailings before the election to just get his positions out could not. The state was not asked by Judge Davis to justify the burden of not being able to use the public information, but they offered basically a single central justification. Other people made millions of dollars, paid billions of dollars to get email lists, not these HAVA lists, many of which were likely not current, with no denomination as to party preference or demographics. And by selling this to contestant at the price offered, that was about $40, there was no denial that offer was made, it would offer something of value. That is unconstitutional. The value of the list is is unconstitutional because it doesn't justify the burden. The value of the list is obvious for political and election purposes because other campaigns are spending millions of dollars on lists that are equated. They're used for political expression and associate with voters by seeking their vote for your party, that is to say, for you. The context in which Anderson was cited by the state was that allegedly I was attempting to burden the DFL, Hartshorn argued, by requiring that they conform to the U.S. Constitution, including the prohibition of suspect classifications, and also the 15th Amendment, barring any abridgment of voting rights based on race, also enshrined in Article 1, Section 4 of the U.S. Constitution, as ex parte Yarborough, the 19th Amendment, barring any abridgment of voting rights based on gender, and the 14th Amendment, barring government use of suspect classifications. So what Hartshorn was doing was to take protections designed to protect me, to protect my party, Independence Party, as an independent voter in the Independence Party, and to steal it and apply it to the oppressor DFL National Party was supposedly protected from complying with the U.S. Constitution. In U.S. versus Classic, the Supreme Court had addressed this and found the opposite. And parties like the Democratic Party of Georgia, where Mr. Ritchie is from originally, do have to comply, and their actions are part of the elections machinery. And there is the argument that caucuses and conventions are not part of that if there is a primary. This is what the DFL is saying. This is strikingly similar to the argument in both ex parte Yarborough and in Smith versus Allwright from the U.S. Supreme Court in their all-white Texas primaries for the Democrats. Here, while the composition of the caucus need not be all white or all non-white or all female or male, etc., there is the same kind of state action through the participation statute that the DFL uses to select its candidates. Certainly, the caucus and convention are an integral part of the election machinery in just the same way the primary was part of the general election in Allwright and similarly in other cases. And the court found the Democratic Party in Texas was indeed bound by the Constitution. The exclusion from debates is clearly related to the First Amendment. The whole purpose is to associate with prospective voters and get your political positions and arguments out in front of them, while all the voters can tune in and contrast the candidates and their positions. None of these issues have been finalized in law. All have been in the federal courts. Because I filed a motion October 29th, this year, I believe, with Justice Breyer at the Supreme Court trying to get into the final broadcast debate at NPR November 2nd, 2 days before the election. Apparently, he didn't receive it until Tuesday, 2 days after the debate and on Election Day. So it's being held there until the cert petition is filed. The legal issues can be settled. The purpose here is to collect forward a record to the Senate, not to delay anybody. I ask that the proceeding go forward. Stop arguing about whether claims can be adjudicated, and that is not the purpose of this proceeding. Ramsey County District Court, through this 3-judge panel appointed by Chief Justice Gildea, is essentially ministerial. Its discretion is bounded by its prohibition against finding facts and concluding law. As such, it is a form of high-skilled ministerial duties, with skills of presiding over limited judicial proceedings. As such, it does not violate the exclusive jurisdiction to try the case of the U.S. Senate where they have many lawyers and judges, but only insofar as it does not determine the election. Now, I also asked that the panel proceedings aid contestant in subpoenaing the witnesses, Senator Franken and Secretary Ritchie, and allow some other procedural motions to help the proceedings achieve what I believe is the purpose of the legislature in prescribing these rules to aid the Senate in choosing and seating its membership through election by the people, the voters, and to facilitate the collection of evidence that will help the Senate determine the election contest before it, according to its own standards, as I say, regulation of the state elections of its members, constitutional regulation of those elections, and ensuring that the manner of voting prescribed by the state legislature is also followed. Finally, I want to suggest that Senator Franken be the priority and that the contest on the Independence Party be held until the first part is settled, certified, and off to Washington. That is not to say that the Independence Party should not be discussed, and I do have a right to bring a contest because mine was a statewide election. I was elected Senate nominee by the IP voters, the top race, because I have an interest in preserving it, if that is justice and democracy, for the 2016 and future elections. But Senator Franken should be called first, and others in the Secretary of State office should be called only if germane to the claims affecting Senator Franken's declaration, and the two may overlap. So that is how I'm responding to the efforts by Franken and Ritchie to dismiss this, to not allow it to get to the judges in Washington. And I certainly hope that tomorrow, as the trial begins, that we will pursue the purpose of the democratic elections of representatives to the federal government so it may stay afloat in these dire times. I'm Steve Carlson, and thank you for watching.